welcome to the second junior academic session of CPDP 2020. My name is Ignacio Sanchez. I'm coming from the Joint Research Center of the European Commission, and I will be the moderator of this session. In the scientific unit where I work, the Cyber and Digital Citizen Security Unit, we are happy to support this year the junior researchers that are coming here to present their work to you. The ones that presented their work in the previous session, and the 4 of them that are here with us now. So we have 3 interesting papers that will be presented. They discuss a very interesting topic, which happens to be the topic of CPDP this year, which is artificial intelligence and its influence and intersection with data protection. By extension, also, you will see that their work will touch upon cybersecurity considerations as well. So one of the papers is about automatic decision-making in the GDPR and other regulatory frameworks. Another one discusses the misuse of artificial intelligence, in particular the deepfakes. You will receive a very nice introduction about this new term in a few minutes. And the third one will also discuss a growing problem in cybersecurity, which is the security of the supply chain in software development, but from more a data protection and cybersecurity, a data protection and privacy consideration point of view. So every speaker will have 15 to 20 minutes to present their work, and there will be a round of Q&A after every presentation. So without further ado, I would like to introduce the first speaker to you. Her name is Angelica Fernandez from the University of Luxembourg. She will present the paper Enforcement Challenges of Online Platforms in the Context of Artificial Intelligence, the Case of Deepfakes, and the EU Code of Practice on Disinformation. Angelica holds an LLM in Space Communication and Media Law from the University of Luxembourg. She joined the doctoral training unit on enforcement in multi-level regulatory systems at the University of Luxembourg in 2019, and her PhD is on the topic of regulatory and governance models for online platforms in the context of artificial intelligence. So, Angelica, the floor is yours.
Thank you. Okay. Good afternoon. My presentation is entitled Deepfakes and the EU Code of Practice on Disinformation. And first, I would like to offer a definition of the 2 terms that stand out from this title, which are, I don't know how to pass, sorry. Okay, yeah. So I offer a definition as an introduction, which are to the 2 terms that stand out, which is deepfakes and the EU Code of Practice on Disinformation. So first of all, what are deepfakes? So deepfakes refers to any photorealistic audiovisual content produced with the aid of deep learning. And it's commonly understood to having 2 defining characteristics. So the first one, this is based on artificial intelligence techniques, more precisely on deep learning to automate some part of the video editing process. And second, that it has the potential to deceive someone or perhaps meaningfully affect their lives. So the term implies the misuse for illicit or unethical purposes. And under the umbrella of this term of deepfakes, which is quite recently, because it appears in 2018 on a community post in Reddit, we have different type of artificial intelligence techniques. Which one is the one that most people know is face swaps. So it's taking someone else's face and copying it into someone else's body. And this is very popular in porn, where deepfakes are actually the most popular. But it doesn't mean that it cannot be used in any other context, right? And then there is also other type of techniques like audio deepfakes, which is copying someone else's voices, making them say something that they didn't say. And we have very famous examples on this. Probably some of you have heard of the Gamba deepfake, but if not, there's one that does this. Also, it's important to differentiate deepfakes from shallow fakes or cheap fakes, which is a term that you might usually here in pair with this deepfake term. And the difference is that they are not under the, when we talk about shallow fakes or cheap fakes, there is no artificial intelligence intervention. So it's just audiovisual manipulation. So for example, taking someone's video, someone speaking, and making it in slow motion to appear as if the person is slurring their words, so like if they were drunk, will be considered a shallow fake and not a deep fake. And it's just, you know, it's also very harmful to the person who appears to be drunk and is actually not drunk, but it still is not considered a deep fake as such. And then you probably seen this news 2 weeks ago when Facebook decided to ban deepfakes on their platforms. And then this new policy obviously highlights that deepfakes is an emergent issue. And they offer, in a certain way, because they define 2 criteria for banning deepfakes, a definition which is complementary to the one I just offered. They agree that it's obviously based on artificial intelligence techniques, but for them it's also that the image has been edited or synthesized beyond adjustment for clarity or quality in ways that aren't apparent to an average person and will likely mislead someone into thinking that a subject of the video say words that they did not actually say. So this new policy from Facebook is obviously in view of the US presidential elections, and they force a lot of pressure because deepfakes are considered to be a threat to election integrity. Because if, for example, you see some of your preferred candidate, let's say, doing something that you were not considering, although it's not illicit or although it's not very controversial, then you might even change your voter's intention without knowing it's not authentic. So that's why it is an important issue. And the fact that Facebook is offering definitions in this policy also highlights the fact that this deepfake is an emergent issue and the definitions are under construction. So it's a very interesting case to research. Now, the second term I would like to define, that is more the context, is the EU Code of Practice on Disinformation, which is a policy movement that was encouraged by the Commission in 2018. It's the first time worldwide that industry agrees on a voluntary basis to self-regulatory standards to fight disinformation. The document has a wide range of commitments that goes from transparency in political advertising to the closure of fake accounts. And it was signed by the major tech platforms working in Europe, so Facebook, Google, and Twitter, and Mozilla, as well as by advertisers and advertising industry in 2018. And recently, in 2019, Microsoft also signed a code of practice. And as part of the reporting duties of the different companies, three companies, Twitter, Facebook, and Google, had to report on a monthly basis to the Commission their actions. So from January 2019 to May 2019, which means that we have actually first-hand empirical data coming from these platforms about how they enforce these policies, which is quite rare in general, because we don't have that level of transparency from them in terms of data. So that's also why it was a very interesting subject to research and that I presented the paper. So the paper I presented for this conference focused on the enforcement challenges of online platforms in the context of artificial intelligence, as illustrated by the case of deepfakes and the difficulties in implementing the EU Code of Practice on Disinformation. It focused mainly on deepfakes that will distort democratic discourse and compromise election integrity in online platforms because the Code of Practice actually has as a purpose to fight disinformation. Also, the reports that were submitted as part of their reporting duties were done in the context of we want to try to manage deepfakes or in general disinformation as a threat for the parliamentary elections in for the EU parliamentary elections in 2019. So it makes sense that I studied it against the EU Code of Practice on Disinformation. And the scope of the paper will only be Facebook, because those were the reports that were analyzed, because Facebook is very active in this area, as I've shown, but also because it has the largest market of active users in the European Union, much more than any other social media. And for the data that was analyzed, I will not go into this detail because we don't have enough time, but there were other relevant documents that were analyzed, and I will be gladly answer any questions on that afterwards. So my findings. First of all, only the Facebook report for May 2019 mentions audiovisual manipulation as a threat, And when they mention it, actually the example they gave is not even considered a deepfake. It's just a regular audiovisual manipulation. And there's obviously no mention of deepfakes explicitly on any of the documents. However, and in contrast, the EU Code of Practice does mention deepfakes explicitly once, and also the action plans against disinformation warns against audiovisual manipulation as something that could compromise election integrity. So already we see that there is a divergence between what the policymaker will consider as a threat and what Facebook as a platform or a private company understands. Now, we could say that deepfakes are regulated indirectly via the code of practice if they fall into one of the categories that are subject to the oversight measures provided by the code. So, for example, if a deepfake originates from a Russian account somewhere, then, and then it goes into the platform, most probably it will be caught by one of the automated filters and be deemed as part of some sort of deceptive, inauthentic behavior campaign, as they call it, and then it will never surface on the platform. So in that way, we could say, like in paper, yes, the current measures are effective. However, and one of the most interesting observations is that actually, Facebook just translated the commitments of the code into their own existing framework for automated and human review filtering of content, which is called Facebook Community Standards, and is what de facto regulates the platform. So, for example, if we're talking about a video that shows a deepfake that shows a nudity, then of course it will be caught by one of the filters and it will never surface the platform. But in the case of deepfakes that are able to compromise an election or sway away voters' intentions, we're talking about not necessarily by the content per se, videos that could fit easily into one of those categories, which were tailored for extremist, offensive, or illegal content. So, so it begs the question how it's unclear how these threats are going to be countered or labeled, as Facebook says, to moderate content online within their existing framework. So it means that with the code of practice, there were no additional categories, let's say. It was just like they adapted it to what they already had. Moreover, the scale of disinformation requires or implies in a certain way that automated filtering for deepfakes will be done because of the amount of data that every day they have to process, which raises legal questions of overblocking of content and threatening fundamental rights such as freedom of expression. And if automated filtering it's not working, or like we left it out, then everything is left to the subjective assessment of users, which needs to flag the content on the platform to say that they believe it's a deepfake, for example, and then it becomes a contested piece of evidence, which is already the case in cyberbullying content or harassment content. So between those who, in the terms of deepfakes, those who want to believe that can't spot the fake from the real, and those who rather believe what they're seeing because they confirm their opinions. And this is actually very important because if left to a self-subjective assessment on a case-by-case basis, it means that in the long term, we're going to see contested pieces of evidence or casting a doubt on evidence that is brought upon courts. And in the terms, for example, in human rights violation cases, which rely heavily on footage of these violations, then it can become very troublesome. I also do a little bit of a technical perspective on the paper, but I will not go really deep into that. I would just like to say that forensic technology for audiovisual manipulation is at its early stage. So filtering for deepfakes anyway, if done in an automated way on the platform, is going to be imperfect and unsystematic, although Facebook is actually heavily invested in trying to come up with new technology to detect deepfakes, but it's not quite there. Now, based on the evidence, politically oriented deepfakes that can threaten election integrity are somehow foreseen or anticipated by the code of practice, but they are left under-regulated by this implementation by the different companies, which demonstrates that delegating enforcement of public interest to private companies can be counterproductive, but also that demonstrates divergence between public interest and corporate values in self-regulatory instruments, which is perhaps why relying on self-regulatory instruments to counter AI-based threats such as deepfakes should not be the standard, or is not a very good idea. That's what I argue. And that it's also important to advocate for an EU value-based approach to regulate AI-based threats, especially as I've said, like they rely on Facebook community standards, which is, and every policy actually from Facebook, which shape by the different pressures they encounter worldwide, not necessarily only in the EU. So that needs to be maybe adjusted, and there's a lot of discussion of this concerning EU approach for artificial intelligence, but that's much broader than the topic. And then to finalize, I would just like to talk some policy considerations that which I go much further in my paper. But then for me, it's really important that there is a co-regulatory horizontal approach to fight AI-based threats such as deepfakes. Horizontal because it's what will guarantee that there is no fragmented enforcement. And this is really important in a context of digital age. Also, learning from the context of data protection, it's important that the principles of transparency and accountability are taken as pillars to develop any type of policy. So transparency understood as more data on the enforcement done by platforms, which is also one of the main conclusions from the different reports that we have, independent reports assessing the implementation of the code of practice in general. By different regulators. So I argue that this forcing disclosure of data for platforms is important to shape better policies. Actually, right now, we don't even know how many politically oriented, let's say, deepfakes are there. Not even we know how many porn deepfakes are there. There's really no a lot of information on this. So that's why it's important that that there's this type of disclosure of data. And then accountability understood as a way for users to seek remedy from the platforms that had enabled the circulation of the deepfake in the first place, because otherwise connecting the creator of the deepfakes with the harm is almost impossible, and then users were left without any recourse. So as a conclusion, I would like to say that artificial intelligence amplifies the phenomenon of disinformation by advancing the state of the art and the tools and the software needed to create or manipulate data. And the deepfakes is an area where artificial intelligence shows that it has evolved very dramatically, and to the point that it's now viewed as a threat that can compromise election integrity. And deepfakes are also troublesome because they highlight the capabilities of artificial intelligence to deceive people. Humans tend to trust what they see, and they exploit this weakness. And that's why we've seen that there's different proposals to ban the creation and the distribution of malicious deepfakes, and notably in the United States. But in the European Union, there's probably going to be a formal shift between this self-regulatory instrument to a core regulation, and then the overall assessment report, the official report by the European Commission on the implementation of the code of practice will be out in late spring. So when we will know really what will be the shift in policy making. In the case of AI-based threat, meaningful digital enforcement requires a careful balance between self-regulatory instruments and a punitive approach. Thank you.
Thank you very much. This indeed, we are discussing these days a lot about what AI can do, how AI can improve cybersecurity controls, how we can do better cybersecurity with AI. But it is also true that, like with every technology out there, it will be misused. And when it comes to the misuse of AI, deepfakes is one of the clear examples about that. So it is indeed something we have to look at very carefully. I would like to open now for questions about this presentation. I'm sure that you have many. It's a very broad topic. Just can you please come by and take the microphone?
Thank you very much for your presentation. My name is Javier Lareo. I work in the European Data Protection Supervisor, and I'm curious about the reliability and efficiency of the tools used by Facebook or other platforms to detect deepfakes. If you have or they have published some figures, because I'm thinking about the millions of images and videos that they are published. So even if the ratio of false positives or false negatives is really small, the number of the number of videos affected would be quite high, no? Thank you.
Well, that's why one of the policy considerations is that important that there is disclosure of data, because actually there isn't. We don't know how many of them are caught or not. And in the reports, they don't really specify. And even when they provide information is not great enough to determine whether we're talking about deepfakes or just regular audiovisual manipulation. So that's also an issue. And there was this independent assessment report where Facebook invited scholars to actually take the data firsthand, the enforcement data. It's called the Data Transparency Advisory Group, and it's sponsored by Yale University. And they did this report that it's independent and neutral. And then one of the main conclusions is exactly that although they had for the first time the privilege to get access to all this data, they could not determine if the enforcement was done correctly or not, because they didn't have enough data, and that's it. So it keeps on being the same cycle. That's why I think, I argue that forced disclosure should be the first step to actually shape better policies, because otherwise we'll always be not knowing enough. And it's been argued that, for example, always these companies change their policies, and then it's 8 months later, 1 year later, that we actually see the impact of what they've done, because we don't know the data until much later, and whether we see the effects. So I think that's why it's important to force disclosure to have more data.
Yep. There is time for another question. Yes, please.
I have a question regarding what is your opinion in terms of liability for such platform, and I want to make my question practical. So let's say that government has some interest in influencing the next election within the European Parliament, and this government is setting up a dark group that is putting a lot of deepfakes on Facebook to influence such election. But that this is discovered, and let's say an association actually gathers all these deepfakes by making screenshots, downloading them, and so on, builds a case, and then arrive in front of whatever the competent tribunal is, and makes the point that in this case there has been a violation of the GDPR principle in terms of transparency, fairness, and other bunch of rules. What should be the liability of Facebook as a platform who did everything it could, so to say, to prevent such deepfake from being released, compared to a dark group whose liability will probably never have been able to be taken up in front of the courts because they were far away and it's really unclear where these deepfakes were coming from? Do you think that we should think about a system where by default the platform should be held liable, or is that asking too much, so to say?
What a question. So in terms of liability and the current framework, of course, Facebook will not be liable according to US law and also EU law. So there's nothing basically that could be done, yeah, that's it. But in terms of the person who maybe be harmed by the deepfakes, they have legal under the GDPR, because they process their image, and also under defamation rules to go to court and actually ask for some remedies. So there is actually a very interesting article on Belgian law who actually has some provisions for people who have been subject to pornographic deepfakes. So their face had been swapped into someone else's body, to actually seek for recourse and remedy in court. So that's what I can say. But in terms of liability, this is a huge debate. And of course, right now there's nothing that could be done, and that's why maybe it should change. But let's see if with the new Digital Service Act, platforms are going to be held more accountable. And then accountability instead of liability, which I want to stress that.
Thank you very much. I suggest that we go to the next presentation now. Thank you very much. Our next speaker is Álvaro Feal from the Carlos III University in Spain. He will present the paper "Don't Accept Candies from Strangers, an Analysis of Third-Party SDKs." Álvaro received his bachelor's in computer engineering from the University of La Coruña and his master in software and systems from the University Politécnica de Madrid. He is now a PhD student working at IMDEA Network Institute. He's working mainly in analyzing privacy threats in the mobile and web ecosystems using static and dynamic analysis techniques as well as network measurements. So Álvaro, the floor is yours.
Thank you very much for the introduction. No, this is not it. Okay. Sorry for the delay. I didn't know in advance which one was my file. So, again, thank you for introducing me. This is joint work with my colleagues from Indiana Wars Indiana Wars Institute, Universidad Carlos III de Madrid, ICSI Berkeley, University of Calgary, and AppCensus Inc. First, I would like to thank our funding bodies because for helping us on making this research, and I want to make a disclaimer and say that all comments are wrong and do not represent those of the funding bodies. I want to start by talking about access to personal data. So many of you probably know, if not all of you, that already on the web there are certain third parties that can actually access your data by the means of, for instance, third-party cookies. And the mobile is actually no different because there are third-party SDKs or third-party libraries that are embedded on mobile applications, and they also have the ability to gather different data from the user. Furthermore, actually on the mobile, there's a lot of information available for collecting, such as the location of the user, unique identifiers, the contacts that the user is talking to, and even different trends and behavior of the user. So going a bit deeper into what is an SDK and why developers use them. So SDKs, or software development kits, are a piece of third-party code that, that developers introduce into their applications to help with developing certain features. So for instance, let me give an example. If I have an application that I'm developing and I want to give my users the ability to log in using their Facebook credentials, instead of building this functionality on my own, I'll probably go into the Facebook web page, I'll look for the Android SDK, I will download this piece of code and bundle it together with my own application. So this means that third-party SDKs or third-party libraries allow developers to code faster, to reduce costs because, well, they can ship their product faster and they also can save costs on actual production. Furthermore, from a pure software engineering point of view, code reuse is a good thing because the more people are testing this code, and it's probably more robust and less prone to have bugs. So this is why SDKs are pretty prevalent on mobile applications. There's a couple of examples here taken from Exodus, which is a web page that analyzes applications, and there's a couple of Google examples that are using over 40% of mobile applications. The Facebook login, which is the case that I was talking about before, for instance, is using around 20%. And then an example of an advertisement SDK called Unity 3D is used in around 7% of the cases. But not everything is good here because there's previous research has shown that actually many of these applications in their privacy policies do not talk about all the SDKs that are embedded into the application, leading to a lack of transparency for the user. So what are the privacy risks more concretely? So in both Android and iOS, if I'm a developer that I want to access a given piece of information or a system resource from a given user, let's say, for instance, in this case, I want to access the contacts. Well, then in that case, the way in which I give notice and I receive consent from the user will be through a banner in which I say, hey, I'm a developer, this is my application, and I need to access your contact. Do you agree to this collection of data? And the problem here is that all the third-party SDKs that are embedded in an application actually inherit the same permissions as the host application, meaning that if I have an application that is able to access the contact, so will any other third party that is included. Furthermore, there's no difference for the user when a given permission is required only for the application or only for a third-party SDK. Therefore, there's a lack of transparency for the user. And furthermore, we've seen that this actually happens in reality. So this is a screenshot of the terms of service of a third-party SDK that is telling developers, well, if you need to use my SDK, then I need you to request this given set of permissions, some of them being especially interesting from a data protection point of view, such as define location. Furthermore, previous research has shown that third parties can actually be deceptive. For instance, they have been found to be colluding to share personal data of users without appropriate consent, or to use deceptive ways to access data such as the location of the users. So therefore, this has implications for regulatory point of view. Under the GDPR, the developer of an application is actually liable from the behavior of the app. Therefore, the developer needs to be aware of what are the implications of the SDKs that are included in the application. Furthermore, there has been regulatory pressure put into third-party services that actually are doing this kind of third-party service, mostly by the FTC in the United States. To the best of our knowledge, such actions towards third-party services are not as common from within Europe. So in this talk, I want to talk about different research questions and open challenges from the detection and attribution challenges of third-party SDKs on mobile applications, the challenges on classifying and making a taxonomy of SDKs, and then the privacy and regulatory compliance aspects of these third-party SDKs and their implications. So regarding detection, there's mainly two methods. On the left-hand side, you can see an example of what I was talking about before, the Exodus web page, in which their main way of detecting SDKs and analyzing applications is static analysis. So the way static analysis works is that you actually have to look at the code of the application and other static resources to try to understand its behavior. The problem here is that this is actually a higher bound, because even though you might be able to serve a given piece of code, this does not mean that it will be actually executed in real time. Therefore, this is not actual evidence of behavior of the app. On the right-hand side, I have the example of AppCensus, which actually uses dynamic analysis. Dynamic analysis, contrary to static analysis, actually relies on running the application and monitoring the runtime behavior to get a lower bound into third-party presence or application behavior. And actually, this means that every observation is actual evidence of the behavior of the app. But because of the need of actually exercising the application, which is usually done through artificial automatic inputs to the app, then it's possible that some of the behavior will be missed by the scrutiny of dynamic analysis. Furthermore, both methods present different problems for the attribution of who is actually behind a given piece of code. For instance, this is an example of the code that should be included for using a third-party SDK, and you can see that this says cf.iee, and this is in reality a third-party SDK, which is called mobi.info. This type of obfuscation, which means changing the code to avoid the scrutiny, makes it really hard to automatically and at scale run a static analysis for third-party SDK detection. Just to give some context, mobi.info is actually a third-party SDK that allows developers to generate revenue without showing advertisement to the user. So in the case of dynamic analysis, let's imagine that I have my own application, com.Álvaro Feal, and that we are able to serve two different domains from which the application is communicating to. The first thing that we will do is actually differentiate between first-party and third-party domains. In this case, alvarofeal.com will be a first-party, whereas mylinealmedia.com will be a third-party domain. Actually, if we try to attribute mylinealmedia.com to the third-party service behind, we could find that this is mylinealmedia, but if we actually go a step further, this has been acquired by AOL. And AOL has been acquired by Verizon Communication. Therefore, because of the dynamic behavior of these companies, there's actually several jumps from the first attribution step to the final third-party company in charge of running the service. Next, I want to talk about the classification of third-party SDKs by its behavior. So the problem here is there hasn't been much of an effort on actually providing a formal taxonomy of third-party SDKs, because actually characterizing the way in which they work is very difficult. So what we did in this work is take the top 50 applications of Google Play we detected the SDKs using the methods previously reported, and we manually analyzed, using different information that was available on the internet, what these SDKs are doing. So this is the taxonomy that we came up with, and I want to take a special attention into the last row, because actually these three cases are more important from a data protection point of view, because actually social networks, analytics, and advertisement SDKs are most likely to collect data, because actually many of them rely on tracking the user to provide the service that they do. So I was talking before about how it's difficult to actually do this classification automatically. And one more example of this is if you look at the development case and the advertisement case, you can find Unity 3D in both of these categories. This is because one SDK does not provide one single business model. For instance, you might be using Unity 3D in your mobile game because you are doing 2D or 3D graphics. But you can also use the another service of Unity, which actually allows you to include advertisement into this game. Finally, I want to talk about the implications for privacy and regulatory compliance on the use of third-party SDKs. So we were talking before about how there are different types of SDKs that rely on data collection. And we actually went and looked at the different data collection practices that these SDKs were doing in the top 50 apps that we analyzed. I want to remind you something that I said at the beginning, and is that third-party SDKs actually inherit the same permissions than the host app. And this is one reason why they have access to this type of information. And we saw that it's common to find data collection and SDKs collecting identifiers, both resettable and non-resettable, and behavioral data such as location. And why we make a difference between resettable and non-resettable identifiers is because if the user has the ability to change the identifier, then he is able to unlink his identity from previous action that he has taken. And this actually is part of both Google's and iOS's policies, in which they say that third-party trackers should avoid collecting hardware identifiers because the user does not have this mechanism to reset it. Another problem will be custom events. So custom events in analytics applications, some of them allow the developer to set very specific and fine-grained information about the behavior of the user. So let's imagine that this is a dating app and that the developer has set the different things that he wants to know. So for instance, he might be interested in knowing that, well, a given user click on my settings, or that a given user change his age settings. But what about if he wants to know that a given user send a super heart to another user? Well, this also has data protection implications, because this is sensitive data, such as, in this example, sexual orientation. Furthermore, it is also important to talk about specific audiences. So if a given developer is targeting children with his application, then actually it needs to be aware that whatever SDK that might be included in the application needs to be compliant with the special provisions in the GDPR, or in the case of the United States, with the COPPA rule. So because of previous auditing actions, actually Google has come up with a list of self-certified ad network programs that claim to be compliant with both GDPR special regulation for children and with COPPA. The problem here is that there is a lack of an actual certifying body that checks whether this self-claimed COPPA and GDPR compliance is actually true. And actually, previous research has also shown that in the case of COPPA, applications that had been certified as COPPA compliant were actually in potential violation of the law. So with this, I would like to go to my final conclusions, in which I want to talk about ways in which transparency could be improved from different actors. In the case of SDK providers, I believe that they should show very clear terms of use to the developers that are including their SDK in their application, because actually, as I said before, developers are liable for what data collection happens in their application. Therefore, there needs to be a contractual way in which they can understand what these SDKs are doing in reality. On the other hand, the platform itself could actually advocate for better transparency. For instance, you see here a screenshot in which this is the code basically for declaring a new permission, and there is no explanation given. So on the right-hand side, this is a much better example in which actually there's a clear explanation of why a given permission is needed. We believe that this should be always the case, and furthermore, that there should be differences to the user for when a given permission will be used by the application or by a third-party SDK. And finally, app developers themselves need to do a good job of being transparent towards the user. So once they're able to understand the different SDKs that are included in their application and the behavior, they should actually show a clear privacy policy to the user so that they can understand what the application is doing with their data. This is an example in which an application developer that wants to include an application in Google Play has the ability to not upload a privacy policy. And we claim that this shouldn't be the case. The app developers should always be clear about their data collection practices to the user. And with this, I would like to conclude and open the floor for questions. Thank you very much.
Thank you very much. It was clearly much more technical than the previous presentation, and that is actually good. That is actually good because when it comes to data protection, it is important to consider not only, let's say, one particular dimension, not only the technical one, not only the legal one, but let's say the interplay between the different approaches. So, when I introduced this article, I mentioned that it was about the security of the supply chain. This is maybe a terminology that is used more on the cybersecurity side of things, but actually this is a growing issue also in cybersecurity. So the software development is not anymore an isolated, let's say, process. So developers, indeed, they take external libraries, and the product that ends in the hand of the end user is actually an aggregation of those libraries. And there's been many cases in which there was a particular vulnerability in one of the library that produces a cascading effect that ends up impacting all the software products that include the library. So at the end, I see that you are actually looking at the same problem from a different perspective, from the perspective of the impact on privacy and data protection. And indeed, I see that transparency is a key point in tackling this issue. So I would like to now see if there is any question about this topic from the audience. Yes? Can you take a microphone, please?
Hi, so Julien Rossi from University of Technology of Compiègne. Does it work? Yeah. So it was a great presentation and very interesting. My question is whether or not you're aware, and it's because that would be quite interesting to hear about, of any study done either by computer scientists or social scientists on the perception of these SDKs by the developers that are using them, and on maybe the socio-economics of them using these SDKs, and to try and understand really, why they are relying on them. Do they perceive the threats that are there? Are they maybe having a cost-benefit type of calculation, something like that? So I don't know. So yeah, my question is, are you aware of any of such studies? Because they would be really interesting to hear about.
So that is actually a great question. And I am not aware of this, but I agree with you that it's very important to understand how developers see this. If they only see the benefits, if they are aware of the privacy risks, because at the end, this is clear that they have benefits, right? They want to ship their code faster, they want to make more money by having less developers, but also they should be aware that there could be retaliation if they actually do bad things in regards of privacy, right? So I completely agree with you. I do not know of any specific study, but I agree that this is something very interesting and that needs to be looked at and understood.
So would you like to answer the... sorry.
No, I have a question.
Okay. I believe there was another question from this... yes.
Hi. Hello. James Cole from Brown Rudnick, which is a US law firm in London, so another lawyer in the room. Apologies. You raised very interesting issues. There was a case in the UK, which was the Lloyd Google case, which was an intentional hack of Safari by Google, which, as you may or may not know, are you familiar with the case?
No.
Okay, so it's now at the Court of Appeal. It's a very complex case. Google are fighting it every step of the way. It's essentially trying to get jurisdictional leave to serve Google in the US for an intentional hack of the Safari browser to enable effectively this, where users have said, I don't want to be, I'm switching off tracking, but they've effectively hacked their way through that. I mentioned this in the last case, but when we're talking about the asymmetry of power, the legal fees on that case for the plaintiff alone are £15 million. So God knows what Google is spending, but they're spending a lot because they can. It's just very interesting to me to comment on that case in the context of this, because of course your developers will probably be relying upon the terms that they're getting from Google. The developers won't have any assets. So if there's ever going to be a legal case for breach on a scaled basis, it's going to be Google who are going to again be facing an action. And I guess I'm just throwing that out there and trying to think about how you would effectively build an argument of chain of causation and loss and damage from the end user through the developer to Google. So I'm not producing any answers, I'm just throwing that out there. But it's very interesting. So thank you, I thought it was a great presentation.
Thank you very much. So I don't come from a legal background, so I cannot answer on the legal part of the question. But I think that maybe I'm taking this through a rodeo, but I think that there is still a bit of hope, at least on the side of Google collaboration, because if there is external auditing of the platform itself, and there is a show that, well, third-party SDKs or app developers might be doing something wrong, then in many cases it's in the best interest of Google to actually change. And for instance, in some of the previous work that I was mentioning, in which within Google Play Store apps, we could find that there were cases of site and cover channels, which are basically deceptive ways to accessing personal data without the user's agreement or consent. This was notified to Google, and Google realized that this is outside of its own policies and decided to introduce changes in the platform itself and on the operating system to disallow for this. So in the legal grounds, I have no idea if it will be possible to, in some way, beat Google on court, but I know that through cooperation with them, when some of the problems lie in the platform capabilities and they have the ability to change it, well, sometimes they allow for small steps for better transparency and better privacy for the user.
Okay, thank you very much. I suggest that we go, yes, but maybe we can leave it for later. So let's go for the last presentation. If there is still time at the end of the session, we will open a round of Q&A for all the speakers today. So the last speakers of this academic session are Giovanni De Gregorio and Eduardo Celeste from the University of Milano-Bicocca and the University College of Dublin City University, respectively. They will present the paper, Digital Humanism, the Constitutional Message of the GDPR's Framework on Automatic Decision-Making. Eduardo is an Irish Research Council Scholar at the Sutherland School of Law of University College Dublin, where he is currently completing a PhD thesis on digital constitutionalism. Giovanni is a PhD student in Constitutional and Public Law at the University of Milano-Bicocca and academic fellow Bocconi University. His research activities focus on constitutional law, media law, privacy and data protection law, with a focus on constitutionalism in the algorithmic society. So the floor is yours.
So thanks, good evening everybody, and today we'll start to talk with Eduardo that we'll start to work on this paper, and our main interest is just to understand why we start to work on this paper that, as you can see in the slides, talk about the definition of digital humanism and how we can provide a constitutional interpretation of Article 22, or for those of you, of course, we don't know what Article 22 is about automated decision-making processes and data subjects. So basically, it's not just important how our paper is structured, but what is important is to understand why we decide to start this project, why we start to write this paper. Because we have seen, of course, we have a lot of papers where scholars from the tech perspective, the legal perspective, have tried to answer what is the interpretation of what the Article 22 means when, of course, ban the data controller to subject the data subject, sorry for this repetition, against, for example, automated decision-making processes and so forth that affects this kind of legal rights. But what we try to do with this project is just to provide a constitutional interpretation of Article 22 that go beyond basically technical and economical and legal interpretation of Article 22. Because what we try to propose in this paper is that we know very well that the relationship between human and machine is changing, especially with the developing of artificial intelligence systems. And we know very well what kind of promise artificial intelligence systems are doing and what are the potentialities, for example, the calculation of the likelihood of serious crimes, rather than for the credit score. We know what China is proposing, and so forth. So this is not just important. This is important to understand what in the European Union, what the kind of European constitutional values could mean when we talk about the automated decision-making process. And in order to do that, we need to our papers start to understand how data protection raised in the European framework when we talk about automation. So the first part of our paper tried to understand what was the first reaction against automation basically in the second half of the last century, especially when we focus on the framework of the Council of Europe, if we mention Convention 108, or if we focus, of course, on the European framework, the Data Protection Directive, and then the Charter of Fundamental Rights. And so now we'll leave the floor to Eduardo, that will basically picture what happened before, and then we'll start to understand what kind of constitutional interpretation we want to propose when we want to read Article 22, and so what kind of constitutional interpretation we have when we focus on automated decision-making processes.
Thank you very much, Giovanni. So it's very interesting to notice that actually both Convention 108 and the OECD guidelines didn't mention automated decision-making at all. And the national data protection legislation in force at the time, they didn't mention automated decision-making except for one, the French national data protection legislation, the Loi Informatique et Liberté. So we did a sort of like a legislative archaeology there, and we looked at the legislative process, which then brought to the elaboration of this piece of legislation. In 1976, the Chirac government introduced a bill on data protection. And in this bill, it's very interesting to notice that among the first 3 articles, 2 of them focused on automated decision-making. We are in 1976. So Article 2 prohibited judicial and administrative decision solely based on automated decision-making, and Article 3 essentially included a sort of like right to explanation. Then the bill was subsequently modified, and it was promulgated in 1978. This version was slightly different. The version of 1978 indeed differentiates between judicial decision and administrative decision. What is really important to notice is that concerning judicial decision, all judicial decisions, not only those solely based on automated decision-making, were banned, while in relation to administrative decision, only those solely based on automated decision-making were prohibited. And this is interesting because then we can compare, and this is what we did in our paper, we compared the text of the Loi Informatique et Liberté and the text of the Data Protection Directive. And what we notice is that essentially there are a lot of influences. The Data Protection Directive somehow overtakes the distinction between judicial and administrative decision, so it focuses on the effects of the decision. But what is important to notice is that the Data Protection Directive restricted the focus of its scope of application, essentially only regulating decision solely based on automated decision making. Now, after this first archaeological history of the provision on automated decision making, the second part of our paper essentially studied, analyzed the underlying constitutional values, the constitutional values which underlie the GDPR's framework on automated decision making. Essentially why? Because we know Article 1 of the GDPR clearly states that one of its main objectives is to protect personal data. However, at the same time, the GDPR aims to protect fundamental rights and freedoms. Therefore, we believe that it's very important to understand what these fundamental rights and freedoms are in order to contribute to the scholarly debate on automated decision making. What are the longer-term values that we want to achieve with a partial prohibition automated decision making? And we essentially identified three main constitutional values. The first one is human dignity. And why? So before moving to human dignity, just to specify that one of the reasons why we decided to delve in this analysis, in this constitutional analysis, is essentially because we strongly believe that the GDPR plays a para-constitutional role. So essentially is helping to translate constitutional principles to face the challenges of the algorithmic society. And we posit, we frame all this discourse, all this conversation in the context of what Giovanni and I, in our research, we call digital constitutionalism. And as I said before, then we can move to the slide about human dignity. The main three values that we identified are, first of all, human dignity. Why? Because Article 22 on automated decision-making operates a balancing. It does not include an outright ban of automated decision-making. Essentially, it's saying only those decisions which seriously affect the individual will be banned. And why? Because machines, we know, they're more efficient than human beings. However, they can err, they can make errors, and they can perseverate in those errors. However, what the GDPR aims to preserve is the unicity, the unpredictability of the human being. Professor Floridi elegantly put it, comparing the human being to the apex legomena, which are the terms, the unique terms which only recur once in a text. Or as Michel de Montaigne put it, men are similar to an uneven, irregular movement. They are polyutropous, they are multi-phased. So the unpredictability of human being is what needs to be preserved. This is why the human being is dignus, so is worth protecting. And this is why reducing human life to machine-readable content is not acceptable. And we learn this from our history. Human beings have already been reduced to machine-readable content, to digits. So the GDPR essentially reflects our right to escape from a blind determinism at the mercy of public and private dominant actors. And in this way, we preserve not only the dignity of one single individual, but of a whole diverse and irrational humanity. In this way, Article 22 translates human dignity in the context of the digital algorithmic society. Today, human dignity also means not being sacrificed on the altar of economic efficiency. And this is why we strongly believe that the GDPR is advocating for a new form of digital humanism, a conception of the digital society where human beings resolutely outrank machines, technology, and ultimately economic efficiency.
So now probably you are wondering about what are the other two, let's say, constitutional pillars that we analyze for interpreting Article 22 according to what Eduardo and myself said so far. Basically, the second principle is, I can say this is a bunch of principles because we have called it the balancing of powers. But inside the balancing of power, there are more constitutional principles, especially for for protecting democratic values like transparency, like the principle of rule of law, and now we will try to explain to you why. Because when we focus on Article 22, and especially paragraph 2, we found a lot of exceptions to the rule that Eduardo described so far about the ban of automated decision-making processes. So basically the question will be, but what about all the consideration, all the observation that we said so far about the protection of human dignity if there are exceptions that allow the data control to do basically whatever they want when automated decision-making processes are involved? So this is a basic question. Can we tolerate dehumanization? So this is the basic question. And actually, if we focus just on Article 22, will be quite, it's not just enough to focus just on Article 22, because it's not just the answer. The GDPR, as all the legal frameworks and legal, of course, regulation needs to be focused and analyzed comprehensively. And especially if we focus on Article 13, Article 14, and Article 15, we can say that it is true that Article 22, so there are exceptions. But at the same time, there are obligations for the data controller to provide information to the data subjects about, and this is all the debate about the right to explanation, about the logic of the processing. So what happens when an automated decision-making process takes a decision that affects the legal rights? So of course there are transparency obligations, but however, you know very well that here we are facing a transparency paradox. Because on the one hand, we have this kind of obligation, but on the other hand, we have, and we know very well, that some kind of artificial intelligence system can lead to black box effects. So these are basically the transparency paradox that we are facing when we focus on EU data protection law. But what is important, however, is that the GDPR provides these obligations for the data controller, and so this is an expression of, this is an attempt to rebalance the powers between the asymmetry of power between the data subject and the data controller when automated decision-making processing are involved. But moreover, this is not just important for transparency, but it's important for the rule of law. Because we know very well that these technologies are increasingly developed, programmed by private actors. And you know very well that private actors are not subject to the respect of fundamental human rights unless there is a regulation requiring to do so, like the GDPR, of course. So basically, the GDPR and the rules of the GDPR allow an horizontal translation of some safeguards, some constitutional safeguards that apply horizontally also to private actors, ensuring the rule of law. Basically, it avoids that the private actors developing artificial intelligence systems basically are free to define the standards of protection of these rights, creating a legal framework, a paralegal framework competing with the legal framework provided by state actors. And this is very important when we focus on the balancing of powers. But this is not enough, because there is a third point, due process. And this is included in paragraph 3 of Article 22. And this is crucial, because of course we can think about transparency, we can think about human dignity. But what about when we focus on the process on which these data are involved, when of course automated decision-making are involved? And of course, due process is another way to remedy the asymmetry of power. And how? And of course, it's a way to complementing human dignity. So the idea to protect the dignity of humans. And how? Especially the Article 22, paragraph 3 includes what is usually called the principle of human in the loop. And we know very well that in some way the GDPR asks that in some way the data subject can require the data controller the human intervention. Of course, there is a huge debate on what is the definition, what are the boundaries of this human intervention. But what is important is that in some way the GDPR tries to proceduralize the process, especially when these data are, of course, processed by automated decision-making technologies. And so this is quite important because allow gives the data subject a tool in order just not to be, again, dehumanized in front of course, against decisions that could be totally automated. And this is important because, as Eduardo already stressed, this is important in order to leave humans to have the last word, especially when we especially deal and rely on these technologies to decide things that really affects not only our legal rights, but just our everyday life. Think about scoring systems, smart cities, access to data, and so forth. So due process is very important. This is not a case that also in the field of freedom of expression, there is a huge debate on due process and platform responsibility. But however, it should be fair to say that due process is not the solution, okay? Because of course there are other fundamental rights or legitimate interests that can clash with this kind of obligations. And just to mention two of them, of course we have the freedom to conduct business think about the developers, that of course are private actors, and the freedom to conduct business is enshrined in the European Charter on Fundamental Rights, so it's worth deserving protection. But at the same time, there could be also the legitimate interest of public actors to restrict the fundamental rights of data protection, for example, for reason of secrecy and national security. But however, so the question is how to find a balance when we want to provide due process obligations and due process rights, let's say. And so the question again is, can human dignity be undermined by the protection of other fundamental rights of interest? According to European constitutionalism, actually the answer will be yes, because of course we have not an axiology of rights when we focus on our constitution system. But however, what is important to stress, and this is the last point basically of our presentation before final remarks, is that due process does not just protect individual rights. It protects a more collective dimension of the rights, protecting especially democratic values and the rule of law again. Because of course, think about that due process allows you to understand, especially the right to human intervention, what's happening when your data are processed. And this is important for in a democratic society in order to be aware of what is happening with your personal data. So basically at the end of this presentation, we basically go back to the picture that we show at the beginning of this presentation. And the most important thing to say is that we try to propose a new system, a long-term strategy that our constitutional system in the EU can provide, especially when we want to understand what Article 22 can mean in the European framework. And this is why we have tried to propose a definition of what we try to call digital humanism. Thank you so much. If you have questions, we are here for you.
Thank you very much. Very interesting topic indeed. It connects to so many things. It connects to the topics of explainability, like you discussed. It connects to transparency and the logics involved. I'm sure that there are a lot of questions for these two gentlemen, so we have a few minutes to take some of them. Who would like to go first? Yes.
Thanks for the presentation. Mark Cole, University of Luxembourg, but also one of the editors of EDPL. And just as a kind of an advertising element, as you may know, we have a Young Scholars Award every year, and that's why it's always nice to hear potential contributions for the following years to our journal. I have a question. You base your idea on Article 22, which makes a lot of sense, and try and identify what is behind the idea of Article 22. In doing so, you obviously touch the basis or the basic question of, is GDPR more a human rights-oriented legal framework, or is it also the free flow of data was supposed to be enabled as well? And that's why maybe your argumentation could be reinforced, and I guess you are doing that by looking at the original basis of the fundamental rights frameworks. And there specifically, you mentioned the French history. You probably are aware of the fact that the German data protection approach, the famous Volkszählungsurteil, where the Constitutional Court developed a right to informationelle Selbstbestimmung, so informational self-determination, exactly based on Article 1. They said the free development of personality, which is laid down in the German Constitution in Article 2, is enriched by a core element, which is in Article 1, human dignity, and that is inviolable, and that's why somehow too much automated collection of data is unacceptable because it makes human subjects to turn into objects, okay? And that's why I think it would be helpful to include in your thoughts what historically is the basis of GDPR, but not going too far, because some people reduce the discussion and say, well, GDPR is the concretized form of human rights protection. No, GDPR has two functions. It's also supposed to enable free flow of data, but I think specifically for your approach, digital humanity, it might be helpful to say, what is the human rights basis? So my question would be, how far have you included that, or are you on purposely starting on the secondary law level, which is we don't touch Charter of Fundamental Rights, we don't touch Article 8 of the Convention, or are you doing that as well and you just didn't present it for time reasons? Thanks.
Thank you very much for your thoughts. Actually, they're very, very useful, and we actually partially covered in our paper, like we mentioned the right to free development of personality, and the census decision of the German Constitutional Federal Court as well. The reason why essentially we didn't start our paper from the constitutional dimension is essentially linked to the fact that we wanted to start from an analysis of the provision on automated decision making and going the other way around. So of course I think that it would be very useful for us to integrate maybe this part and to highlight in this part in the introduction, when we, for example, we say that the GDPR has this twofold aim of guaranteeing the free flow of information and protecting fundamental rights. But what we wanted to highlight is that somehow this provision on automated decision making was included in the Data Protection Directive in 1995 without knowing why, what was the origin, what the longer term values behind this were. Because I suppose that we all agree that of course human dignity, the due process and the rule of law are behind the GDPR. But the problem is, in relation to this specific provision on automated decision making, which is somehow different from the other provisions of the GDPR, because it does not merely focus on the protection of personal data, but is more like oriented towards like broader values. What are those values? And this is what we try to do in our paper. But definitely, thank you very much for your suggestion.
So, if there are no more questions, I would like to, we can close the panel, and I would like you to join me to congratulate the four speakers today. Thank you very much.